Howdy and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Kimberly Wong, partner and head of litigation at Cooper's, we will be discussing workers' compensation, applicants' attorneys, workers' compensation liens, and how to effectively work with applicants' attorneys on cases. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals, trial, co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome to the show, Kimberly.
Thank you for having me here.
It's always a pleasure. As we get into this topic, Kimberly, can you tell us a little bit about your history in terms of handling workers' comp versus civil cases? And I think we should be clear that you are not an applicant's attorney. Is that correct?
Correct.
But you have worked with applicants' attorneys extensively.
Many times.
Can you expand on that in terms of how that has gone forward in terms of your practice and the third-party workers' comp overlap in a lot of what you've done over the years?
So I've been in practice doing plaintiff's personal injury for over 16 years, and a handful of my cases have been what is known as third-party industrial personal injury cases. And in those, there's an underlying workers' compensation case. So our client would have an applicant's attorney. That's someone who represents the injured worker because they were injured on the job. And so I would be handling the civil third-party case, and there are many times when you need to talk to their workers' comp lawyer just to help them on their end for their case, but also for support for your civil third-party case.
As we get into this, while most people may have some concept, what is workers' compensation?
You hear them talk in code AOE, COE, and that's, does the injury arise out of employment or in the course of employment? That's the number one thing that they're looking for. I'm not an applicant's attorney, but I've learned some of the lingo over the years. And if the injury did happen AOE, COE, then they have a workers' compensation case.
From the perspective of workers' compensation, does workers' comp cover, say, non-economic damages, damages to the human being versus economic damages?
Yeah, so there are some major differences between a workers' compensation case and the civil case. One is workers' compensation is a no-fault system, and that reflects a compromise from when the system was originally developed. As we know in our practice, we're contingency fee-based. We have the burden of proof to establish fault and total damages. But in the workers' compensation system, as long as you prove that the injury arose out of and in the course and scope of employment, it doesn't matter who's at fault. And so likewise, what it means is there is a compromise that you can't just get everything. And so the damages are limited to medical care relating to the injury and some disability benefits, which is basically a partial replacement of the lost earnings. Now, on the civil side, you have a lot more damages opened up. There's loss of household services, and the big one is general damages. And if your client has a spouse, the spouse can claim loss of consortium. I also want to note that in the workers' compensation side, even though they can claim the lost earnings and the medical treatment, it tends to be at a lower amount than you'd probably get on the civil side.
As far as this is concerned, in a situation where somebody does not have a workers' compensation case, they're going to have to wait until the very end of the civil case generally before they see any sort of compensation. How is that different in the workers' compensation case?
Well, as soon as the case is filed and if the employer accepts that it's in a workers' compensation case, benefits can happen pretty soon. They don't have to wait for any adjudication on liability or damages. The disability payments and the medical payments will happen. However, it should be noted that there needs to be authorizations and approvals for certain medical care.
So if somebody was injured at, say, a multi-employer job site, they're working as a subcontractor and they're injured either by another subcontractor or by the general contractor, they have the ability to have both workers' comp and a civil suit, a third-party suit. Is that fair?
Yes. And of course, as we all know, that the civil third-party suit can take a couple years, maybe longer, to see any money.
And so this is why having that workers' comp piece can help It may not fully compensate the person for the type of earnings that they were making, particularly if they were a union worker. However, it will help put food on the table in the interim.
Yes.
If it is a no-fault system, why would someone need an applicant's attorney?
Well, applicants' attorneys can be a good advocate in the workers' compensation system because, as I mentioned earlier, they do need authorization and approval for certain care. So if it's questionable whether the person might need surgery, usually need a couple of doctors' opinions. They're not going to maybe accept the first one. Another reason is there's something called a serious and willful petition that's only available in the workers' compensation forum. And forgive me, I'm not an applicant's attorney, but I do know enough that if there is a certain threshold of employer fault, is seriousness and willfulness is what I gather, the employee can get up to 50% additional damages that wouldn't otherwise be normally allowed in their workers' compensation claim.
So there are a variety of reasons, it sounds like, why an applicant's attorney might be appropriate. The other piece that I sometimes hear from either our clients or from the applicant's attorney when we're working with them is that since the laws were changed, this is back when Schwarzenegger was Governor Schwarzenegger, the employer can stand in the way in a much more meaningful way. There are fewer penalties that arise as far as that's concerned. And so without an applicant's attorney, the injured worker on the comp side can find a lot of barriers and a lot of their medical being denied or delayed. Is that fair?
Sure. I mean, doesn't it always help to have an advocate on your side? The employer has an attorney, and not surprisingly, they would use it to their advantage if they knew that the injured worker wasn't represented.
So would it be your recommendation then that if somebody has been injured on the job, that whether this is somebody listening who is a lawyer who might refer the case to an applicant's attorney, or someone who just has stumbled upon this and is listening themselves who's been hurt on the job, that they actually go forward and get an applicant's attorney to be able to effectively advocate and get justice on the workers' comp case?
I think that's a good idea. And also at least the initial consultation is free, and it is a contingency fee too. But in the workers' compensation system, the applicant attorney's fees is capped at 15%.
Typically a much lower rate than what you would see in a civil suit.
Absolutely.
As we switch now into understanding a little bit how that workers' comp arena works, you talked about the employer having an attorney and the deck sometimes being stacked in their favor if there is no applicant's attorney. Does the employer have a right to send the employee to the employer's doctors if the employee has not elected certain doctors early on?
They have two different kinds of doctors. There's an agreed medical examiner and there's a qualified medical examiner. And so depending on, I think, the communications between the applicant's attorney and the employer's attorney, they usually have a list of about 3 or 5 doctors that they each propose, and then they'll strike a couple from the other side's list. And then what's left over is the doctor that the employee or the injured worker would go see. There are some other procedures that probably are more familiar to applicants' attorneys about how it works, because I think when there are disputes, the workers' compensation appeals judge can help resolve those.
When you have a client where it becomes apparent that they need a referral to a workers' compensation lawyer, what types of things are you looking for when you make that referral in terms of being able to work well with that workers' comp lawyer? Because there will be interaction on that case, correct?
Correct. I think it's important that they are a certified workers' compensation specialist. It is a very specialized field, so you want someone who knows the law and the procedures and the forum inside and out. And ideally, one that just practices exclusively workers' compensation, because I know some that dabble and also do the personal injury side. But just like us, it helps for us to be specialists in the personal injury field. I also look at who works at their office. Do they have staff members who are responsive to inquiries? Because the applicant's attorney probably has several hundreds of cases at one time, so they rely heavily on their staff to respond to inquiries and process things on the cases. They tend to be very well trained too, just as much so as the applicant's attorney. So how is their staff? And also, to the extent your client has English as a second language, what languages do their staff members speak? And then, of course, really importantly, because we want to have a partnership between us and the applicant's attorney, can we communicate? Are we on the same page? It's great when the applicant's attorney knows about the third-party case and the importance of certain things that you might need for it so they can be an ally. But even if they don't have that information, are they open to having those conversations with you about how they can best support you and your mutual client?
When you're working with the applicant's attorney, are there advantages in terms of using the applicant's attorney to do things like, say, get medical records, or to the extent that one might need a deposition of some sort that might not be as easy to get early on in the civil case? Are there areas that you found that can have some benefit?
Yes. A lot of times when a client comes to you and they've been injured at work, it's not necessarily obvious if there's going to be a third-party case. And so we have to do some investigation before we can even think about filing. And one of the things that you can do is ask the applicant's attorney for all information that they have. They might have some witness statements, OSHA records already, and maybe some other insights about the work injury. But once we get to the point where you have more information and you want to develop your third-party case, sometimes it can be strategic to ask the applicant's attorney to help you gather some information. I've done it actually in a couple situations. One where I wasn't sure if there was a third-party case, and I selected wisely in the referral to this applicant's attorney, one who I knew was good with being an advocate and persistent and would be willing to help. She went to the WCAB several times to get me a site inspection and an inspection of the machine where the client was injured, because just by reviewing the OSHA records, I didn't think there was a potential third-party case, but she got me that inspection. I attended with a consultant, and from there developed theories and felt comfortable pursuing a third-party case. She also issued record subpoenas to the employer. I gave her the list of things I wanted, and she sent them out, and I got records early and with some persistence on her part, because it's not always easy either in the workers' comp side.
And as tempted as I am to follow this down the rabbit hole of finding third-party fault, that's going to be covered on our next episode, correct?
Correct.
And we'll hear more about this and some of the exceptions that one can use to pursue this.
They can also help you with depositions too. It's less common, but if you have the right partner, they can make it happen.
In that communication piece, do you also work with them to make sure that if your client is deposed or when your client is deposed in the comp case, that you have a copy of that just to make sure that you know what was said by your client?
Oh, I would start much earlier than that. Once you know who the applicant's attorney is, whether it's referred to you or you referred it out, you want to start that conversation early about keeping communication open, to agree to apprise each other of significant events and developments. And one of those is, I want to know when my client is going to be deposed in the workers' compensation case. Sometimes your client doesn't tell you, so it helps to know from the applicant's attorney. And of course, you should ask your client to have them let you know. But ideally, you want to be involved in that depot prep. And frankly, the applicant's attorney might appreciate it and takes a little of the burden off of them, because it's important to really understand the differences in discovery for the workers' compensation case and the personal injury case. And when you're keeping in mind that the applicant's attorney has hundreds of cases and it's a no-fault system, it really doesn't matter what the injured worker says at the deposition, as long as they can show that they were injured at work in the course and scope of work and what their injuries are. That's about it. So if they say things that we would cringe at in a personal injury lawsuit, it doesn't matter in the workers' compensation case. And some applicants' attorneys, they may not realize that. And so it's important that we plan ahead, because the client's testimony can be used against them in the personal injury suit. So it's more than just getting a copy of the deposition transcript. We certainly want one, but we want to be involved early on.
As we talk through this and as we recognize that we want to make sure that everyone gets compensated for the work that they do, there's usually some sort of a referral relationship with the applicant's attorney in some fashion. The civil case potentially wiping out any recovery that the comp lawyer has and thus wiping out any comp fee.
Yeah, I think as personal injury attorneys, we should keep in mind that the applicant's fee is limited to 15%, which isn't that much compared to what we see in the civil side of things. 1. 2, they do work hard. And there are some circumstances, although maybe rarer, that the applicant's fee can be wiped out. So if your client received a third-party settlement or judgment and there's no employer fault, the applicant attorney's fee is wiped out. So we want to make sure that they get paid under any circumstance.
Is there a way in which you find that is helpful, say, assuring them that, look, if it goes this route, we appreciate all the work that you've done. We're going to make sure that your fee is protected even if there's a fault situation that wipes out your fee.
Yes, you should have that conversation up front. And I think if you have a pre-existing relationship, there will be that level of trust. The other thing I've seen as well is if they referred the case to you, they're going to get a referral fee. And so that often can be more than enough to compensate them in their eyes for any loss that they might have on the workers' compensation case.
I want to turn back now to, you made reference to the serious and willful component that can sometimes exist in a case. If the civil case, the third-party case, looks less promising, but there is a situation where the employer fault looks to be quite high, potentially serious and willful, what steps do you take to engage the applicant's attorney to discuss that petition, the serious and willful petition, and how to proceed on that piece?
If I don't think there's a viable third-party case, I will notify the applicant's attorney right away, because as I understand it, there's a 1-year statute of limitation to bring that serious and willful petition on the workers' compensation side. So they need to act quickly to preserve that right, because there is going to be no remedy on the third-party side.
As you're evaluating the client getting the best potential outcome, are there situations where a client may be better off not taking any compensation from the civil case?
Yes, it'll depend on what the available insurance and assets are. And this probably comes up more in the serious catastrophic injury cases, where you'll find a large workers' compensation lien. One example might be if your client was injured in the scope of work, maybe let's say hit by a car as a pedestrian, and the driver's insurance is $100,000. A workers' compensation has paid well over $100,000 already in medical payments. There isn't going to be a better day in the civil third-party case. And you know that workers' compensation, they have an obligation to pay all medical and a certain level of disability benefits regardless of fault. So that is probably going to be the better avenue, even though it's hard to walk away.
And the example that you're using is one that comes to mind almost perfectly in terms of the numbers. It was a librarian who was walking from one library to another, crossing the street in San Francisco, and got struck by a vehicle that did not have a lot of insurance, unfortunately suffered a brain injury from the event, and taking any penny of insurance then created just kind of a morass of issues. Yes, the civil attorney would have ended up with some sort of a fee, but then there would have been credit rights and all sorts of challenges. And that's my long pivot into discussing credit and what a petition for credit is when a person is injured. How does that piece work in terms of the overlap with the applicant's attorney?
So if there's a recovery in the third party case, then the concept of credit comes into play in the workers' compensation case. It's about whether the employer has a credit towards future medical payments, and the employer has to pay its proportionate share before it gets a credit. So as we know, our personal injury cases can end in a couple of ways, one through settlement and one through trial and judgment. So a lot of times there is going to be employer fault, and there's a case that we should all know. It's Associated Construction and Engineering versus WCAB, and that case stands for Comparative Fault Principles Control. And so that's how we figure out what the employer's potential credit is going to be. For example, let's say the client's total damages between economic and general is $1 million. And let's say there was a trial and the jury found that the employer was 10% at fault. So 10% times $1 million is $100,000. If the employer has paid only $50,000 to date, they don't get a credit yet. They have to keep paying until they hit $100,000 because that's its proportionate share of responsibility. Now, if this civil case ended in a settlement, then we're going to have probably some banter back and forth as to what the jury would have found the employer at fault, and then do the calculations there.
As I understand it, one of the avenues that can go down, if there's no settlement in the workers' comp case, the employer can make a request for what is known as a credit trial, where the value of the case and the extent of employer fault end up getting litigated and decided at the WCAB. Is that correct?
Yes, it's fascinating, but I hear it's rare. I have been involved in a couple litigating and settling before a credit trial.
Likewise, I've sometimes been put on standby and told, look, we may need you to come in to be able to testify with your experience as a personal injury lawyer about what the value of this case would be so that the WCAB judge can make a decision on the credit aspect. Is that what you're talking about?
Yes, but I've also been involved earlier than that as well. I know some people who've been on standby or even testified in the WCAB about the value. And by the way, it can be for the value of the case that you litigated. It doesn't have to be someone else's case. So I've been on standby for that. But I've also assisted the applicant's attorney with discovery in the credit trial prep. So basically, when you have that good relationship with the applicant attorney, you've done all the work, you know all the evidence, and basically you shift the focus and you arm them with all the arguments that you would have made if the employer was the defendant so that they know what they can work with. I've also helped them with the experts, particularly the workplace safety expert, put them in touch with our retained expert. I've also participated in the deposition because I've actually been there where in prep for the credit trial, the employer wanted to depose a workplace safety expert.
Have you ever, as part of a resolution with the defense, had an agreement where you can work with the defendant's safety experts so that you can use the position that was taken by the defense of enormous employer fault and have that expert come in to testify at the WCAB trial?
Yeah, so what I recommend is if you know this is going to be an issue, one, ask for an assignment of the defendant's experts. I haven't done it so much for the credit, but definitely for the lien part, which we will talk about probably in another time. And also, it's a good idea to set aside a cost reserve for the probably more modest litigation expenses in prep for the credit trial.
And when you say a cost reserve, what are you talking about?
So I have had that example where we had some depositions that were in preparation for the credit trial. There might be some ancillary investigation or records costs as well. Because in the workers' compensation forum, they don't have a pool of money to advance costs. And so there's certainly a conversation that you'll want to have with your client about this is really for your benefit to set this aside to fight the credit issue.
We talked a little bit about the role of the applicant attorney as far as medical is concerned. Are there steps that you have found are sometimes necessary on the treatment front as far as the applicant and attorney fighting for the things that the injured party needs?
Well, I'm not intimately familiar with what the applicant's attorney needs to do on their end. I do know that they have some influence on which doctors see your client, and there are some that are more employer-leaning, where they routinely find that not much further treatment is necessary. I know that there are terms like, impairment ratings and causation issues. So there's some doctors who might be more employer-friendly on those in the workers' compensation case. So the applicant's attorney can try to steer away from those. It's really no different than what we see in our third-party case, where you see the defendants retain medical experts. We're like, oh, we've seen them before. They always testify the same way for the defense. They never find, a serious injury.
What I was driving at, to a certain extent, was a situation where the treating doctor says, look, we've exhausted conservative care. At this point, I feel that this person needs an MRI or some sort of imaging done because I am concerned that there may need to be a back surgery or some other thing potentially here. And the employer's insurance carrier says, no, not going to do it. And that's a situation where I've found that the applicant's attorney has to go to the mat for the employee in order to move the issue, and sometimes have to go to the WCAB to force it. Have you come across that with your clients?
Yes, I know that there are occasions where they need to be very persistent, that the ins and outs of how they handle it procedurally, I'm not terribly familiar with.
And this is something that I have become somewhat familiar with, just having seen the pre-Schwarzenegger and post-Schwarzenegger. Previously, this was less of an issue because when a employer denied the care, they would end up having to pay triple the value of the care as a penalty. Subsequent to the Schwarzenegger change, there's no penalty. So there's really, the idea of putting that delay in, all it does is make the applicant attorney have to work harder, and maybe they don't have to do it. And then the care just drags on. From a personal perspective, I've seen this happen with my brother. What should have been in a normal world medical care, he would have had neck surgery and returned to being able to work within 4 to 6 months. Through the comp system, it took him 1.5 years. As we kind of wrap on topics related to this first episode on what I see it as kind of a two-part related to workers' comp and the interaction with the applicant's attorney, is there anything else that we haven't touched on here that you think might be beneficial for people to know about?
In working with the applicant's attorney, it may be helpful to know that although they technically follow the CCP and evidence rules like we do, they don't use it in practice as much as we do in our personal injury lawsuits. So if you're asking them to help you with gathering information and discovery for the third-party case before filing, to help them out, they have a lot going on, and also they just might not be familiar with the mechanics of it. And so one thing that I will do, because let me help you, and so I can prepare it for them, and that way I have a better chance of getting what I need and want, and they literally serve it and follow up. So their lift is very little, and it's more likely something that I'm going to get in return, rather than ask them, hey, can you prepare some discovery? And so I would love to get some information on this to help the third-party case.
Can you give an example, say a small example, where you've done something like that, where it has garnered something that you found quite useful?
Well, there's one case I did a whole list for the record subpoena to the employer because I really wasn't sure if there was going to be a third-party case, so I wanted to investigate early. And so the attorney attached it to the subpoena and had a little more teeth, because I didn't want them to know that we were looking at a third-party case. So the fact that it came from her, it made it look more like it was a serious and willful investigation. So the element of surprise. And it turns out for that one, ended up filing based off of records obtained there.
So the assistance with the applicant's attorney on the discovery ended up being something that was quite beneficial to your client.
Correct. And likewise, I used the example earlier with the product and site inspection. It made a whole world of difference in seeing a new avenue of recovery that several attorneys had looked at previously and didn't see one.
Well, and as I've alluded to, we see this as kind of a 1-2 punch in terms of how to deal with workers' comp, third-party overlap, and how to effectively advocate for your clients in those situations. So thank you for being here, Kimberly.
Thank you.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.